Several years ago, two neighbours started an argument about who owned the bit of land that was between their houses. It was running underneath a fence, which was moved, which is a common thing when neighbours have disputes about fences, is because the fence has been moved. So they went back and forth for many, many months arguing, and eventually, as many often do, ended up in court, each side spending over £100,000 in costs, all over a strip of land that was no wider, probably, than my lens here. Front to back of the property, and they ended up in court. As I say, in that situation, one party obviously would have lost, and winner tends to have their costs paid up. And so when you're looking at £100,000 odd in costs, that can be quite costly. But obviously telling the story of where this land was originally placed and who owned the land in the first place is a very important skill.
Yeah, now I can follow up with another property one actually, because I had a very similar one. There were two houses and they were next to each other and they were on slightly different levels. So there was a bank between the two. And the row was, where was the border? Was it at the top of the bank or the bottom of the bank? And both neighbours argued that they owned this piece of land. And we're talking about something that was written almost vertical. And they insisted on their own surveyors. So the judge said, well, we want a valuation on this land. What are we arguing about? And both surveyors, bearing in mind, quite often in court, you'll get a single joint expert. The court will say, right, let's agree on one expert because the purpose of an expert is they are neutral and objective. But in this case, they both had their own experts. But both experts came back and said, this land is valueless. It's actually a liability because whoever owns this land has to take care to make sure there's not a landslip. So if it was the higher house, they would have to make sure it didn't collapse onto their lower neighbours. And if it was the lower neighbour's land, they'd have to make sure it didn't collapse and sort of bring half of the neighbour's garden. And the judge said, they said it's actually a liability. It's worth less than nothing because of the maintenance costs. But the judge said, well, just put a value on it anyway. And they both came back independently and said, a pound then. But both sides racked up about £40,000 in costs each. And in the end, there was so much ambiguity because when the land registry mark out title deeds, it's just a red line. Of course, in real life, that red line, that marker pen, is about 2 yards wide. So it's very hard to work out exactly where the boundary is. And when looked from above on a slope, it's barely registering. So in the end, the judge said, do you know what? I think the equitable result here is to just split it down the middle. So you've both basically, there was talks about like joint ownership and things like that, but that would have, they just didn't get on enough to do that. So the judge just drew, judgment of Solomon, drew the line down the middle, which of course meant it was a score draw. Each side picks up their own costs because there wasn't a winner or a loser. And that's a cautionary tale because that just goes to show where the emotions, because nobody actually wanted this land. You couldn't do anything with it. It was just a sort of dirt bank. But yeah, that basically cost each side around £40,000 each. And of course, it wasn't about the land. It was all, and this is something we want to come on to about, when you say, I want my day in court, what are you trying to achieve? Are you trying to achieve an actual result? Because courts are there to make decisions and say, here's a factual result. They are not there to, mollify people's, grievances or, provide sympathy or to spend 3 days hearing about all the past history of how horrible your neighbour was. That's completely irrelevant. Because it nearly always turns out, and indeed, this particular case, it wasn't about the land. It was about a remark made about somebody's wife at a barbecue 3 years before.
And please don't forget to subscribe to Al's channel, which is Art of Law, which is linked in the description below. And make sure you subscribe here as well, because about 70% of you don't subscribe. So it really helps us. So please do hit that subscribe button both here and over on Al's channel, Art of Law. Now let's get back to the chat. And that brings us on to why we talk about these stories at all in the first place, because I've had a number of questions and requests to talk about how you tell a story, how you present a case in court, if you are unrepresented, so you're presenting the case yourself, how best to go about that, what to watch out for, what is the court tend to look at certain things for. And so we just thought we'd roll with a few of those things in this video. This is sort of an introductory to what might be a series of these type of videos. A little bit like some of them that I've started to do on my website, BlackBeltBarrister.com. You can check some of those out as well. So the way I explain it, I'll just covered it really in the sense that when you go to court, you're asking the court to make a decision. That's either in the form of a judgment, and that's either a civil judgment by the judge or a verdict by a jury, but you're either way, you're asking the court to make a decision. And this might also be for an application. So if you're, let's say you're applying for an order for someone to do or not do something, so an injunction, a mandatory or prohibitory injunction, either way, you're asking the court to make a decision. How does the court make that decision? Well, usually in terms of what the law says would allow them to make that decision. What you are asking for, does the law allow them to make that decision? And more importantly, why? And that's where you come in as the person going to court, the witness, the claimant, the defendant, whatever, because it's your story. And it's how do you tell that story? The best way is obviously honestly, fully, frankly. There's no point trying to hide bits of information because they will come out one way or another. They will be, you're under a duty for a start. We've got a disclosure on both sides. People think that they can just keep something back, and that's not the case. Al, have you got any funny stories of someone, no names of course, trying to withhold something in terms of disclosure and then actually suddenly it comes out to bite them?
It's the other way around. One of the big warnings we always give to people is, no matter how confidential or privileged or secret you think a document is, like an email or something, just assume that at some stage a judge will be reading it back to you in court. And I had this where I sent an email to lovely opposing counsel because, of course, you know, even the very hostile litigation in the background, the barristers all get on. And we were having this trial we were having this trial in Plymouth. So my barrister friend said, "Oh, I've never been to Plymouth. What's it like?" And I just did my tourist thing about, "Oh, you know, it's down nice on the Hoe. There's a really nice lighthouse," and got all nerdy about, "Oh, that's the Smeaton Lighthouse." And of course, they were famous for getting the curve right. But I also added at the end, the court itself, though, is a something tip and smells of a rude word for when you go to the lavatory. And that ended up in the bundle because, of course, we'd use that email to send something, and there was an issue about when something was sent. And the judge actually stopped the tape at the hearing and said, "Mr. Robert Shaw," and just read it back to me. However, we were literally sat in this building, and you've probably heard all these stories about courts collapsing and being really dangerous because courts aren't bound by health and safety legislation because they're crown buildings. And I said, "Yeah, I'm literally sat next to a hole in the ground with yellow and black tape on it. And I couldn't plug my laptop in because there's a sign on the plug socket saying "Do not use, dangerous." So I rest my case, Your Honour. And the judge did have to sort of give a yes, because that was a particular building that had been closed down because they thought that they were getting a posh new building, but then they couldn't afford the posh new building, so they had to reopen it. By which time it had actually been squatted. So I mean, no disrespect to the lovely Plymouth Combined Court Centre. If anybody's ever been there. I also know of a solicitor whose holiday snaps ended up in a bundle. Just like you've got to be really careful what you're dragging and dropping into print.
Yeah, well, the classic one is in arguments, and this is valuable information for anyone that ever thinks, well, even doesn't think that they might end up in court over something. If you're arguing with someone about something, or even if there's a possibility that you might end up arguing with someone about that thing, as Al said, just remember that at some point the judge might be reading it back to you, or counsel for the opposition might be reading it back to you. Because the classic, and it's happened more than once for me, being the barrister on that other side, is when there's a conversation, an argument, a conversation between people via messages usually, because people tend to put more firmly worded things in messages than they might say to each other. They often say in messages, "I'm going to say this and it won't look good in court." So it's a bit of a threat. It's not even veiled. It's an outright threat. It's "I will tell them this and it won't look good in court, will it?" And invariably those are the things, especially if they're not true, if they are proven to be untrue, but it's been put across as a threat. Those are bits that are very useful to read back. And so I'm just going to read back to you a message that you sent on the whatever of which month. Now, you said, now, I am going to tell them X. That's what you said, isn't it? But X isn't true, is it? Now, underneath that, you said, now I'm going to tell them that, and it won't look good in court, will it? And obviously the follow-up is, well, we're in court, and it doesn't look very good, does it? Because it's not true. They've made a threat, and it's not true. So, as Al said, anything you write and send, assume someday that it's going to be read out. And there's a duty to do that. Some things they'll be telling that it was an honest conversation and there's free-flowing thoughts there, but sometimes it very much will go against you.
Yeah, and don't forget now that if you instruct solicitors, competent solicitors will trawl everything on the other side's social media. That case recently with the crypto fraud guy who got sent down, a lot of the evidence in that case was his own social media. Because like all the lawyers, as he was tweeting, were just going, "Oh my God, what's he doing?" Because we were all saying, does he not realise that this is all going to be put to him in court, where he was basically admitting the crime and admitting all about sort of how they're going to handle the litigation. And it's the classic thing, because the best way to win a court case is to just use the material that the other side have provided. Just use their own words against you. Now, Mr. Sosa, I'd like to read you an email of such and such day. I'd like to read you a tweet. I'd like to read you a WhatsApp message. I'd like to read something you put on Facebook or Instagram. I mean, insurance companies will do this in personal injury claims because they will just troll when you're claiming for personal injury. They'll, produce in court all your holiday snaps of you skiing.
The day I was going to say skiing. The day that you claim that you couldn't walk, here's a photograph of you skiing on the same day.
Yeah, that's the whole point. I can't walk now. I have to get around on these things. Outrageous. And I can only walk from the top of the mountain to the ski chalet.
Yeah.
Yes. But this is something that, and I think part of the problem is now there's so many ways of communicating, and it's what do you use court proceedings for? Because what are you actually trying to achieve? Because sometimes, as I said before, it's not the actual end result. People just want to be heard. And I've said that, I've had far better feedback from clients when we've lost but gone down fighting than from when we've won. Because when you win a case, you go, congratulations, we've won. And it's, but you never said that, and I wanted you to put that, and I wanted you to ask them that, and you never covered this. It's like, well, no, that was all irrelevant. We didn't need it. We just need, if you want me to win, because barristers are there to win cases. We are not there to use valuable and precious court time just so you can air your grievances if they are not relevant to the case. And this is a big problem in a lot of cases because, and this is what we want to come on to in how to be the best advocate you can to win your case. I mean, if you don't want to win your case, you just want to go in there, use the fact that it's completely privileged occasion just to say anything you want about the other side without any fear of repercussions, but you don't care losing and paying the costs. Fine, but you will be pushed to get a barrister to go along with that. Because although you are the client and we follow your instructions, we have an absolute discretion as to how to run the case, including which witnesses to call. That's not up to you, that's up to us. I mean, you can always sack us if you're not happy with it, but that's always been... Barristers have to retain their independence, and that includes from their own clients. So we cannot lend ourselves to an abusive process. We cannot ask questions merely to harass, annoy, or upset people or put them in a bad light. We can do that if it's relevant to the case, and sometimes it is. But we can't just do it to make somebody uncomfortable.
And add to that, you can't just ask a question just because they want you to ask if, let's say, it's a hugely disparaging and you're accusing someone of some crime, but there's no basis. There is a limit to what you can say. Now, of course, you will put, that's not true, is it? And you'll put the case in that way. But if it goes to a point where you are outright, let's say you're accusing them of fraud, you're going to that extent. Well, for one, you obviously need the instructions to do that. You can't just do that of your own whim, but also you need some sort of evidence to back that up. You can't just say, this is fraudulent. You are committing offences here, unless there's any basis for it. You can say they're mistaken or they've they made it later, or you go as far as saying it's not true because that's your case. But there are limits to that. And so some people will want you to, as Al said, some people will want you to use that occasion to accuse them of all sorts of things. Now, we can't do that. We can't be the mouthpiece for that either.
No, that's one of the few things. I mean, if your instructions are, I was kidnapped by aliens, we have to run that because that's your instructions. It doesn't matter what we think of it. But if your instructions are, he committed fraud, that's one of the few occasions where we have to be satisfied ourselves that there is some evidence to support that. Because obviously, in a court, you can say anything you want, and it's absolutely privileged. There can be no comeback whatsoever. I mean, don't get me wrong, you can be prosecuted for perjury and contempt. The other side can't do anything about it. But in return for that, there are limits on what accusations you can make, just to stop people, using legal proceedings just effectively just to badmouth people without any consequences. And judges hate that as well, because you could win a case, but the conduct of the case could be such that you would be penalised in costs, for instance. It's like, and we see this all the time in judgments. Yes, this has been proved. However, there was particularly unnecessary and overly aggressive cross-examination, or it's more often it's the tone of the correspondence. If it is all this stuff, I'll ruin you, I'll see you in court. And this is one of the hardest things to get across to clients is, I am being polite with the other side because that is how we are as professionals. If you want to send the letter you want to send, de-instruct me and you can send what you want.
It yourself.
But, judges hate inflammatory correspondence because it's undignified, but more importantly, it just builds up costs.
It's not, and it's not necessary. Yeah, it doesn't go to the issue. I had a few questions the other day. What is an issue? And, well, it's something that has to be resolved. It's something that people don't agree on. The whole point, the other way of describing reasons to go to court is people don't agree. And that can be on a multi-million-pound business deal where the terms have gone awry. Or it can be, is it Saturday or Sunday that, mum or dad spends with the child because they've separated and they can't agree. Well, if they can't agree, then that's where the court comes in. And so that's an issue. It's which day is it? And it's as contrary to what most people in that situation think. It's not about the parents, it's about the child. Is it better for the child that it's on Saturday or Sunday? And of course, the simple answer to that is, well, which house do they usually live in? And therefore, which is likely to be more beneficial for the following morning to go to school and that sort of stuff. So again, the story is important. So again, trying to get across what the court's likely to decide. Sometimes it's fairly clear cut, but people won't often understand that. Why is it clear cut? Why can't they do this on this day? Well, they just won't, because it's not about you and the other side. It's about the child. Is it better that the child is in their own bed the day before school? Yes. Well, that's where they're going to be then. Usually, at least, unless it's shown that there is a pattern and that it's perfectly fine to massage that situation so that it's okay for that child. But otherwise, it's fairly straightforward. And again, it's asking the court to make those decisions. Those are what the issues are.
Well, this is it, yeah. Because what I want to do is, because people might know, I'm very involved with advocacy training. I train the pupils, the new barristers, and some very, very senior sort of barristers, which is actually quite hard because it's like, well, how am I even good enough to do this? I'm also supposed to be designing a course now with some other people who are cleverer than me, luckily, to design a training course to train people, to train lawyers for another jurisdiction. So that's my, next 3 weeks of heavy reading. But to give you some inside tips as to things I will say to other barristers when we're training them. The one I use a lot is, and I think this is very relevant, especially to litigants in person, as advocates, we see the case as a battle to be won. But for the judge, the case is a problem to be solved. So help the judge solve the problem. That's the way you win cases. You win cases by making the judge's life as easy as possible. And also, 95% of cases try themselves. If you get the evidence out there, you don't really need to make the closing speeches. The judge can read it. He understands, or she understands, all the evidence and the points. But the trick is to get that material, that relevant material, out there, and to not swamp it with other things. That is your job. Your job is to present the case as simply and concisely and easy as possible for the judge to understand. So it's, and this is why when you start bringing in and throwing the kitchen sink, you just lose the focus. I've seen cases that perhaps should have gone a different way, but the actual good point has been swamped with all the bad points. So one thing you need to learn very quickly is filter out, trim the fat is the thing I say to people. Filter
Yeah.
out anything that's irrelevant. I mean, the one point, and this is to jump back on what Dan said at the beginning about telling a story. I use this a lot. I say to them, barristers, we are essentially storytellers. We are trying to sell a narrative, and we have all the issues that anybody writing a book or doing a film or a play has. They need to make the story interesting. They need to make the points compelling. It has to have an arc. It has to be easy to follow, and it can't have any plot holes. If you're the best points you can ever make to a judge or jury are ones that are absolutely obvious common sense. Sometimes you do have to ask them to stretch incredulity a bit. It's like now members of the jury, especially. Now at first this does sound implausible, but we need to look at this and look at this, and implausible things happen all the day. Impossible things happen every day because the laws of large numbers. But generally speaking, the trick with advocacy is to get all the evidence out there, and then identify that evidence, and then say, well, that's all the evidence, but what's the conclusion? You never tell a judge or jury what their conclusion is to be. You always invite them. It may well be, members of the jury, or it may well be, Your Honour, that if you find this, then you'll find this. Or if you are with me on this, then this consequence. That's how you do. You always undersell it. But it's telling a story. And in the same way, you might have a fantastically brilliant argument that you've worked on. And this happens a lot when we're teaching the pupils, especially all the younger barristers, because they go, oh, I found this great point. But I actually don't need it, because you can make the same point just from another document in the evidence that isn't even, so you don't even have to worry about cross-examination and challenging people. It's like, I can make that point just on that. So in the same way that they always say with screenwriting, be prepared to cut your best scene. Sometimes you have to cut your best argument because it is not needed. And
Not necessary.
this is it. Now, to give you all the dark arts, okay. Most people, I think, who get their information about trials from the media, you might well imagine that how does a trial go? Well, we call all the witnesses, they say what they say, we challenge them and ask cross-examination questions, hope they'll change their mind, and we try the Perry Mason thing, which very rarely happens. Sometimes it does, especially if you're a gentle cross-examiner. You can get people to agree with you. But generally speaking, both sides get there, they make their case, you put your questions to them, and you tease out the evidence. And people think, well, you do that, and then you've got all the evidence, and you write speech, you get to the jury. No, it's exactly the reverse. When you start a case, the first thing you need to look at is, what do I need to prove to win this case? So if it's a negligence case and you're the claimant, I need to show that there was a duty of care, there was a breach, and there were losses that flowed from that. If you're defending a criminal case, I need to show that somebody else had an opportunity to actually commit this theft. So although I was there were gaps where somebody else could have done it. You then basically write your closing speech. You go, right, what do I need to be able to say to the judge? I need to be able to say, well, it's clear there's a duty of care, here's the obvious breaches, and here's the consequences. Right, that's my closing speech. Then you write your opponent's closing speech. What are they going to say? You go, right, how do I undermine that? Once you've done all that, that's when you start going through the evidence. And you start pulling out, and you go, right, I need to be able to make this point about this duty of care. Well, I could question this witness, or I could do that. Having said that, there's a document here, there's an email where they say, yes, we accept responsibility for that. That's brilliant. I don't need to ask anything about that. That's my first box ticked. And you do the minimum you can to get the evidence. And advocacy is all about control. You need to control the narrative, which means you need to control the evidence, which means you need to control the witnesses. But the best evidence is the stuff that is incontrovertible. It's in writing. I mean, judges are told this, that by the time things get to trial, And this is why they very rarely say people are lying. They know that 3 years down the line, people have it in their heads as to what actually happened, as far as they remember it. And, memory is reconstruction, not recall. So what they are now remembering might be irrelevant. So what judges are told is, especially in commercial disputes, the best evidence is probably all the stuff that was put in writing before anybody knew there was going to be a dispute. Because they were probably being honest. Now, as soon as a dispute arrives and people start writing sort of CYA emails and correspondence, because in anticipation of litigation, they are preparing the groundwork for their own case, and they're trying to get admissions, or at least, paint people into a corner or put them in an awkward spot. Prior to that, it's just like, here's an email. And this happens all the time. The number of times I've been sunk on commercial cases about debts and stuff, where there will be an email somewhere going, yeah, sorry about that, bit of a cash flow problem, but can you give me till like the end of the month? And they've just admitted they owe the debt. And then you get all the rows about, oh, the work wasn't up to standard, or it wasn't delivered. And judges just go, there's an email here from your guy saying, basically he'll pay if he's got more time. So clearly he was happy with everything. Let's face it, this is just a cash flow thing, isn't it?
Yeah, seen that a number of times. You see the defence saying that on the one hand, we don't accept that there was a contract, we don't accept this, and we don't accept that. But then it goes off on telling a story, and then eventually it says, well, we did pay the first 12 months, or we did pay the first 18 months, and, we just don't agree about this, we don't agree about that. Well, both can't be true. You can't deny the contract and have fulfilled the first half of the contract or whatever. So, yeah, the story is important, and the documents are important.
And this is why lawyers, you see, if you've got in-house lawyers in a firm, they will write things without any admission of liability and purely on a pragmatic basis. We're making this payment now, but, we don't accept. And then that leaves open the possibility of rowing about it, as opposed to the judge just going, I'm just going with this. I did a case once where it was about whether somebody had resigned from a particular organisation, because there'd been their sort of annual AGM, which turned into a bit of a drink session, and there'd been a big blazing row. So I'm taking my bat home with me. And then the person the next day was, afterwards was going like back at the thing going, well, no, I'm still a member. I didn't resign. Yes, you did. So it was all about whether somebody had resigned. And there were 9 witnesses in that case to try and reconstruct what had happened at this drunken part, AGM. However, there was a document that sort of said, here's the rules of the constitution of the institution. If you wish to resign, you can do it on 2 weeks' notice by putting in writing to this address. And the one thing that hadn't happened. And what was interesting about that is I've always said, judges don't like to find people are liars. In this particular case, the judge came back, because it was really embarrassing for me, because it was a late instruction and the solicitors had done all this work. And I had to be very careful, because I had this document. My only point was, and I didn't even need any witnesses, because one thing everybody agreed on was he hadn't done it in writing. So I said, I'm just going to waive this document. And there were 3 massive ring binders full of paperwork. But I had to be careful, because if I win the case here, when it comes to the cost thing, the judge might wipe out most of the costs, going, you didn't need to call these witnesses or take these statements. But anyway, the judge came back and he said, the one thing I found amazing about this case is everybody lied. He said everybody lied. There were 9 witnesses in this case, and every one of them lied. However, it's all on this piece of paper. The one thing everybody does agree on is there was nothing put in writing. But what's great is I've made my decision. It says I'll put it in writing. I need to go away now and find a way of punishing both sides in costs, because he was just so old to the conduct of the case. And it was a tricky one, because they'd been as bad as each other. It was, how did you penalise both of them? If you said, well, each side pay their own costs, well, the party that would normally have to pay have suddenly got a windfall. And if it's like, well, you're not getting your costs. And in the end, the judge basically awarded our costs, but only half of them. He said, that's the best thing I can do is, you're entitled to your costs, but I'm going to deduct them because you're getting half of them. And the other side, you should be paying the costs. So, I mean, this is the thing to remember. Judges do not like bad-tempered sort of, litigation and high-emotive litigation. They spend all their time, especially in areas like family, but just generally. I mean, we always say, commercial law, at least that's nice and non-emotional. But usually, I've had directors like coming to blows outside the court, the courtroom.
Oh yeah, it can be just as heated in commercial disputes as well, especially when they've been working together a long time. Yeah. So I mean, that's the thing, and any dispute like that comes to court, you have to, some degree, you have to cut it with a hot knife, because you're cutting through years of people working together, and the working relationship, the emotions and the agreements, the disagreements, all of it's cut aside, really. It comes down to, well, what's the issue? Well, he said he was going to do this and didn't. And, I was supposed to do that, but I'm not doing that because he hasn't done. And so, well, what does the contract say? And it just comes down to the contract and a sprinkling of law that some people might not understand. So, we've got laws on mistakes. We've got laws on, whether something was allowed in the first place. So all these things the judge might rule through. But otherwise it's, well, what's the disagreement? What's the issue? What does the law say? Here's where we fall. And there's no concern about anything else. So telling the story. And I think if we will move to do a few videos like this on advocacy and how to tell the story, and the teaching that I do, I think is on I'll say a more basic level, but that's not to be disparaging to those that are on the bar course, because that's in some ways is probably just as hard, but in a very different way. Teaching someone advocacy that's never really done it before, because if you come out of university and you go into advocacy, which is where I teach at the bar school as a visiting lecturer basis, and teaching examination in chief, cross-examination and conferencing skills for the first time, I think it's very difficult for people to pick up the first time. And again, I think it's your difficulty, Al, when you're teaching experienced barristers is, well, what do you teach them new, and how do you teach them something differently when they're very likely set in their ways already?
Well, my difficulty in teaching experienced barristers is they're all better than me. Because I had one recently. We went away, and this was what they call a new practitioner program. So this is barristers who've been on their feet for like years, 3 years or so. And the exercise is all based on a clinical negligence case. And one of the women in my group, she was a clinical negligence barrister. And she was so polite that she was nice enough to not make it obvious when I was pronouncing some of the medical terminology wrong. But, you have to be honest about this thing. We do actually have techniques for dealing with when people are very, very competent, in that we can actually do things to perhaps just make it even better. I did my video Hample method about, like I said, normally we pick on one obvious mistake, correct that, rather than try and do everything. It's just correct one mistake at a time until you've knocked all the rough edges off. But you can do a similar thing with people who are very competent, which is, that's great. Here's a way that we think you might be able to take it to the next level. But like I said, the advocacy is all about control. And a lot of the time it's about minimalism. Don't get me wrong, sometimes you will get these brilliant barristers who are very forensic. They will go through every single point by point by point by point, and just demolish the case. However, I'm a very broad brush person. I'm a big fan of never more than 3 points, whether that's your overall argument or in cross-examination. 2's better and 1's best of all. The best, I'm a big fan of the 1-question cross-examination. As the great Irving Younger once put it, who was like the godfather of advocacy training, brilliant American judge, he said, cross-examination is a commando raid. It is not the invasion of Normandy. Get in there, get what you need, and get out as quickly as possible before anybody even realises what you're up to. And that is the way to cross-examine. But people have this idea that they want to have somebody in the box for hours or days going, and you did this, and you did this, and I'm going to show you another document. Half the time, you can get the one point you need from even knowing you've got the point. And nothing is more disarming than going in there, being very friendly. Hello. Now, first of all, let's just see what we can agree on. We can all agree on this. Brilliant. Now, just help me here, and just ask that one question. The Ghislaine Maxwell case was a great one, where somebody demolished a day's worth of testimony with one question, which was all about, they had somebody from Epstein's organization saying about lots of things. The entire case about something that happened on a particular island. But they had somebody giving all the background about the Epstein organization and what happened, and not seen this and not done that. And she gave evidence for like nearly an entire day. And then they stood up to cross-examine and went, "You've never been to the island, have you?" "No, just sat there." And that was it. And that was theatrical thing to do as well. I mean, because it was just like you just sent the message. This evidence is completely irrelevant, so you don't even
Mm.
need to consider it. And to be honest, sometimes the best cross-examination is I've got no questions because it's great that because sometimes you can get the material because a lot of the time, a lot of what is in dispute is not relevant to what the judge has to decide. And I will say this, I will say, especially, and you get away with this now because court time is so precious. I say, look, a lot in dispute here, but very little of it goes to anything you need to decide. So I hope I will be forgiven if I don't put every point to every witness.
Mm.
Because there's this rule that you have to put your case to a
Yeah.
witness. If you don't challenge them, you are deemed to accept what they say. So you can't not ask them questions and then at the end say, you can't trust the person, they were lying and this isn't true. They just say, well, you never put that. You've got to say that and give them a chance to respond. Now, of course, they will inevitably come back and just stick to their guns. Although sometimes, if you're careful, you can tease things out, especially from witnesses who aren't one of the parties necessarily. They're just there on behalf of one of the parties, but they're just trying to be as honest as they can. You can tease things out, and also you can sometimes do it in a way where if they're not giving you an answer to the one, the classic question is like, you're here to support your friend. I mean, again, Irving Younger gives the brilliant way of cross-examining a defendant's mother in a criminal trial, which is that you don't if mum's provided an alibi or denied washing his blood-stained clothing or something like that, you don't steam in there and go, "You're a liar! You're a liar!" It says you stand up and you go, "You love your son very much, don't you?" And then you sit down. He said, "What's the first thing the jury are thinking?" "She's a liar." These are the little tricks of the trade that
Yeah.
we will teach you because I'm a big believer that you do not win cases by being good. You lose cases by making mistakes. So you minimize the opportunity to make mistakes. And it all comes back to this idea of control. I mean, I'm sure everyone's heard the old cliche, you never ask a question you don't know the answer to. And that is very true. One exception to that possibly is when you don't care what the answer is. But be very careful you don't care what the answer is. Be very, very careful. I mean, sometimes I'll ask questions about just to ease my way in with a witness. Like I've done that with people about it's been mentioned they like sport or they play football, so I'll have a little chat about what team they like or something like that. But you've got to be very careful though. You never know. The judge might be a gooner or something, and there's some Spurs fan that you want him to leave. So this is why I say you're always safer never asking a question unless you know the answer. And the safest thing to do is to not ask the question. At any stage, you should always be. I mean, again, Irving Younger. I keep channeling this guy, which means plagiarizing. He said, "Never miss an opportunity to shut the f up," because And this is the question you should be asking all the time: have I done enough? Can I sit down? Because the worst thing to do is to ask a series of questions that've got all the answers you want, and then fall into the trap of trying to do a bit of spectacular making a point with the witness. And we call it the fatal question too far. Because and this is feedback I give to the advocates a lot, which is, it's not the which you're trying to persuade, it's the judge or the jury. And also, be very careful to know, be very clear what's a question and what's making a point. Now, you'll get some advocates who will effectively ask a question in a way that makes the point. And so you can give a little nod to the judge or a little eyebrow to the jury. But generally speaking, you just ask questions of the witness and then you make the points from those answers to the decision maker. Because apart from anything else, the worst thing about putting something to a witness and going, "Well, how do you explain that then?" They will. They will explain
They
it.
will
So you
always
never get. And I
explain it.
have asked a question too far, and I did it in a four-handed fraud case, and I was on a real roll. I'd got some great answers out of the prosecution's main witness that were completely undermining the case against us. It was brilliant. And instead of just sort of sitting down and making the point to the jury, which was, he did everything our guys did, and it's accepted, that was just not fraudulent. It was just a mistake. It was a business that just went under for legitimate business reasons, as businesses do. But instead of making that point to the jury, I tried to make it to the witness. witness, and my final question is to sit down was, yes, so you did everything that the defendants are accused of. Yes, but you weren't arrested, were you? Yes, I was. What? and I didn't even get a chance to go beyond that because another co-counsel for one of the defendants just shot up and tried to salvage it. And there's nothing worse in the roving room afterwards, where you've basically, I'm not just taking out my guy down, I've taken everybody else's. I just reassure myself that they were clearly guilty anyway, so I don't have to feel bad. I shouldn't feel too guilty about that.
And it's also it's also important to remember you're not making the points when you're asking the questions either. You're asking the questions because either you have to ask the question because if you want to say someone's dishonest or misremembering something, you have to put it to them. But also, you ask the question to get the evidence. But it's one of those two reasons you ask the question, not to make the point. The point will come either in a speech to the jury or submissions to the judge. I mean, as Al said, you can sometimes make a point if you're asking that question, but it's not necessary. It can be effective, but it's not necessary at that moment in time. You're asking the question because you have to for legal procedure, evidence or rules, but not because you have to make the point at that stage. And of course, in the criminal trials, the jury hear that process because it's better that they have that opportunity to hear it to make up their mind, but not because that's when it's required.
Sorry, but we'll do that. We'll ask a series of questions to paint people into a corner because the evidence isn't in dispute. So you can do that. You can do a series of questions. It's true, isn't it, that this happened and this happened and this happened, and you get to the stage where the obvious conclusion is there. It's very tempting to put it to the witness, but you've led them that far. I mean, sometimes you'll put it to the witness and they will either agree with you, which is great, you've just won, or they will disagree with you, which makes them look really unreasonable. Because what you need is for the decision maker to be going, there's only one answer that you could have given there if you want any credibility. But a lot of the time you will leave that last question because it's not really a question, it's making a point. And this is, again, these are all tips that we will share with you because there's no great magic to advocacy. I mean, don't get me wrong, obviously it's a skill that people train very, very hard for. But the fundamentals, if you stick to the fundamentals, the trick is to try not to be bad. It's not to try to be good. It's to try not to be bad.
To not mess it up. Do the
very few good advocates out there.
Do what's necessary, but without messing it up. Exactly.
Yeah, I am not a good advocate, but judges seem to like me because I mean, this is the thing, be the advocate that the judge looks forward to having in court because you make their life easy. And I'm a big minimalist. I keep it simple. I'm a very non-aggressive cross-examiner. And sometimes that works. I did that had a stabbing when my client stabbed a police officer who was in clothes at the time. And we ran self-defense. And the police officer who came in, obviously not very happy about being stabbed with a screwdriver as it happens. And he was a big guy, and we got chatting. You're a big guy, blah blah blah. Get down, Jim. Yeah, did you play rugby? We had a little joke about rugby union and rugby league. It's like, oh yeah, rugby. Did you play proper rugby or rugby union or rugby? There was all that. We got quite a nice little bit of a banter going, and I was just going, you work out. You're a big guy. Your job on the streets is to have presence, isn't it? Yeah. You're the guy they put there when everybody's kicking off. You're the guy they send just to stand there and go, oi, watch it, aren't you? Yeah. And in there, I said, look. Not saying you did anything wrong whatsoever, but if somebody suddenly turned around without and suddenly saw you there, might it have been for that fleeting second reasonable to think, I might be in trouble here? And he went, yeah, I suppose so. And if you've got something in your hand, you might just lash out with it.
Reasonable belief for self-defense.
Yeah, flipped out at half time.
Yeah. Excellent. Well, look, we'll be doing more of these videos, breaking down advocacy, the skills, the traits, as I said, no secrets, just a few different processes, different ways of doing it.
Millions of pages of information. I've got box files of all this material, which I will share with you in a not breaching any copyright sort of way. This is the irony. We write the exercise. Sometimes write exercises for these things. And
we can shoehorn it in under education, I'm sure, some way, one way or another. But we're not sure. This is probably going out on both channels. Make sure you subscribe if you're on whichever channel you're on. Pop over to the other channel. Art of Law, if you're not familiar with Al's channel already, you should be by now, but it'll be linked in the description. Make sure you subscribe there. Let us know what you think of this free-flowing conversation style on advocacy, and hopefully it's addressed some of the questions and the comments that have come through for advocacy. I know I've seen quite a few of them. So there'll be more to come. Any closing words, Al?
No, this is another thing. Yeah, when you do your closing speech, just keep it really simple and go, well, the thing I always tell people to say to judges is, first of all, just see if they need to hear from you. So if it's a plea in mitigation, I've had so many people come in and do massive pleas in mitigation to try and get somebody to follow the pre-sentence report. And I've said, in real life, we just go in and go, Your Honour, I'll be inviting you to follow the pre-sentence report. So unless you're going to do anything otherwise, I'll shut up. And I've actually had judges come in and say, Mr. Robertshaw, I'm minded to follow the pre-sentence report unless you want to talk me out of it. So that is actually something. And a lot of the time, you know what? The best thing you can ever hear from a judge is, I don't need to hear from you.
I was just about to say, it's a bit of a funny story, really, because I had one such case where the other side was a litigant in person, i.e. not represented. And the judge, having heard all the evidence, came to me first and said, I don't need to hear from you, which is code to us that I'm going to side with you unless the other side gives me a reason not to. But then the other side actually burst out laughing in court, thinking that obviously our case was so bad that the judge didn't want to hear it. But obviously that's the other way around, because the judge was satisfied already. And then obviously the question went to the other side as, tell me what you would like and tell me why I should rule this way. And obviously they went on for 15 or 20 minutes saying what they wanted and why. And then the judge just obviously ruled against them for it, but giving them that opportunity to put the case for it. But I was just sitting there for about 15, 20 minutes thinking that they must be under some illusion that they've won the case because of the laugh that came when the judge said they didn't want to hear from us. But such as it is, little code words. So with that, we'll thank you for your kind attention. Hopefully you like this sort of arrangement, and we'll do many more of them. Like the video, subscribe, and we'll see you next time.
See you next time.